I will be discussing on the role of solicitors in England and Wales.
Hi, my name is Arisya and I will be discussing the roles of barristers in England and Wales.
Hello, I'm Tang Pei Sing. I will be discussing on the distinction of solicitors and barrister, as well as solicitors and barristers should be fused or split profession.
My name is Rachel Lim and I will be discussing on the fundamental values of the English legal system and how lawyers are able to uphold and contribute to it.
I'm Ong June Tung. I will also be discussing on how lawyers uphold the fundamental values of English legal system and concluding the impact of lawyers towards the fundamental values.
Hi, I'm Joel Chu. I'm going to discuss about what are the attributes that lawyers should possess in order to carry out its role professionally.
Oxford Dictionary defines solicitor as a lawyer who prepares legal documents, for example for the sales of land or buildings, advise people on legal matters, and can speak for them in some court of law. The total number of solicitors on the roll at the end of December 2020 was 152,528 in England and Wales. Solicitors' work includes interviewing clients and negotiating on their behalf, divorce and family matters, provisions of advice and representation for those charged with criminal offences, claim for compensations following an accident, claim based on consumer contract, employment and housing dispute, and the early preparation of civil and criminal cases for court. Many of the works of solicitors are paperwork, for example, writing letters on behalf of clients, drafting contract, leases or other legal documents, preparations and executions of wills, and dealing with conveyancing. There is an increased tendency towards specializations among solicitors, especially the larger firms. Some firms will deal only with either particular areas of law or particular kind of clients. Types of work done by solicitors depend on the type of firms he or she works in. For many years, conveyancing, divorce, and probate were the financial mainstay of most solicitors' practice, but after the Administrative of Justice Act 1985, which allowed other people to become licensed conveyancers, although solicitors reduced their fees, they still lost a large portion of the work. This led to a demand for wider rights of advocacy. Solicitors had full rights of audience in county courts and magistrate court, but their rights of audience in higher court are very limited. All solicitors usually could only act as advocate in the Crown Court on an appeal from the magistrate court if he or other solicitors in the firm had been advocate in the original case in magistrate court. Although solicitors could deal with preliminary matters in preparation for a case, they had no rights of audience in open court on the High Court until 1986. In the journal articles titled Solicitors' Advocacy and Higher Court Rights, mentions that the Court and Legal Service Act 1990 changed the basis for the exercise of rights of the audience of solicitors. It made a solicitor in private practice had the right to apply for a certificate of advocacy to enable him to appeal in the higher court. The certificate was granted if the solicitor already had experience of advocacy in the magistrate court and the county court, took a short training course and passed examinations on the rules of evidence. These rights are now governed by Part 2 of the Act. The position is that right of audience must be granted by an authorized body and the Law Society as well as General Counsel of the Bar. Is now an authorized body for this purpose. The granting of solicitors' advocacy right is governed by the Higher Courts Qualification Regulation 1992. All solicitors must have practiced for a period of 3 years before applying. In Section 36 of Access to Justice Act 1999, it provided that all solicitors will automatically be given full rights of audience. A new system of accreditations as a criminal advocate, which included 2 levels for advocacy, was announced in 2015. The first certificate was granted in 1994. Until 2015, only 6,500 solicitors had qualified to be advocates in higher courts. A solicitor with an advocacy qualification also will be entitled to be appointed as Queen Counsel and also higher judicial posts.
According to the Oxford Dictionary, A barrister is defined as a lawyer in the UK who has the right to argue cases in higher courts of law. To be more specific, they specialize in courtroom advocacy and are professional legal advisors. They are usually independent, working to represent people and businesses in both tribunals and superior courts, open up cases for them, advising clients, and giving their expert legal opinion on a specific matter in their case. They can be employed by government organizations where a large number of barristers work for the Crown Prosecution Service in criminal courts. Unlike solicitors, they specialize in an area of law, whether it would be a family law, criminal law, and others. It is this courtroom advocacy which makes barristers to be looked up upon. Barristers are able to start legal proceedings in court provided they are eligible to conduct litigation. On a side note, litigation is a legal proceeding whereby a lawsuit is brought into action in the court. This procedure cannot be conducted by just anyone as it is a reserved act and can only be done by those who have the authorization to do so. The BSB, short for Bar Standards Board, is responsible for regulating barristers in England and Wales. They set the requirements for barristers to ensure their skills are always maintained in a tip-top shape and observe the legal services and advices provided by the barristers. Barristers are also subjected to a code of conduct set by the BSB. As of 2020, there are a total of 17,078 practicing barristers in England and Wales. In the past, it was necessary for the general public to get in contact with a solicitor to use a barrister. With the Public Access Scheme or the Direct Access Scheme established in 2004, allows general citizens to hire a barrister directly without needing to go through a solicitor anymore. This way, barristers are able to conduct litigation, represent their clients in court, while also having complete influences on the case they are taking. It was not necessary for a client to go through a solicitor to hire a barrister anymore. Hiring two lawyers can be especially expensive, and some clients are able to conduct litigation on their own and only require a barrister to represent them in the court. A barrister must 1. Complete a training course approved by the BSB. 2. Own a practicing certificate provided by the BSB in order to give public access services. 3. Inform the Bar Council's record office that they are intending to undertake such work. And 4. Meet the requirements as set out by the BSB handbook. A special rule called the cab rank rule is only applicable to barristers. This rule is derived from the job of a taxi driver. They must accept the next passenger available to them regardless of who they are and where they want to go. Similar to the name, barristers operate in such a way as to accept a client on a first-come, first-served basis, provided that the client's case is under their area of expertise and if they have time to take on the case. The reasoning behind this rule is to prevent barristers from filtering out the clients that they have a personal dislike towards, either based on moral or political grounds, and to ensure that every client gets a fair representation in the court. Like a layperson, barristers are also prone to make mistakes and engage in dishonest behaviors. They are not immune to the consequences of their actions in law. In an example case of Saif Ali versus Sidney Mitchell and Company 1980, barristers can be sued on the grounds of negligence for giving the erroneous advice to their clients. This is because they owe a duty of care in resolving their clients' cases with reasonable competence. This barrister in particular had given the wrong information on whom to sue and thus making the claimant unable to file a lawsuit against the intended person. In order to avoid this problem in the future, complaints against barristers can be made to the BSB provided that the client does not enter into a contract with the barrister. However, if a contract has been made, complaints are to be made to the legal ombudsman for them to resolve complaints about the services provided by the barristers.
Unlike in most other countries, practicing lawyer in England and Wales are currently categorized into two split professions as mentioned by Hong Yin and Arisya, which is solicitors and barrister. There are also a lot of differences and similarities between solicitor and barrister. Firstly, the difference between solicitor and barrister is the duty. Put very simply, barristers tend to practice as advocates representing clients in court, while solicitors tend to perform the majority of their legal work in conveyancing. Secondly, the differences can be shown at the solicitors and barrister training. After completing a degree, you have to make a decision whether you wish to practice as a solicitor or barrister because this is where the routes split. In solicitor training, you must complete a vocational 1 to 2 year course, which is legal practice course after your LLB or GDL, followed by a 2-year training contract. From 2021, you will have to take the Solicitor's Qualifying Exam (SQE) in order to qualify. In barrister training, you need to complete the vocational component of bar training after your LLB or law conversion course. After this, barristers will do a 1-year pupillage, which usually take place in chamber. Thirdly, the work pattern of solicitor and barrister are also different. Most solicitors are employed by a law firm or commercial organization as an in-house solicitor, whereas barristers are self-employed and they cannot form partnership unlike solicitors. Lastly, workwear differences existed where barrister in court was expected to wear traditional court attire in the form of a long black robe and wig. As a solicitors, there is no dress code. Despite their differences in responsibilities, similarities also can be found. Sometimes, the link between the two professions has become more blurred and confused. In perspective of duty, as mentioned by Hong Yin just now, solicitors can go through some training in order to obtain higher rights of audience, which enable them to represent client in superior court. This means that solicitor can now perform many of the functions of a barrister up to a certain point. In contrast, the barrister could not deal directly with the client. Instead, client had to approach and work with solicitors until 2004. In 2004, the Bar Council amended rules under the Direct Access Scheme to enable clients to directly contact to barrister in order to get advice or represent them in court. It means that a barrister can have direct access to client as what solicitor did. Although the legal profession in England and Wales is a split profession, sometimes work carried out by the solicitor and barrister will overlap, although they train and qualify in different ways. This is in contrast to the field profession that exists in other jurisdictions such as Malaysia, where the same legal professional can carry out of the work that a barrister and solicitor does in the UK. Among the possible advantages of a field profession are one system of training where lawyers in practice can choose whatever professionalism they want after completing study. Also, the cost will be reduced so that it is not necessary to hire 2 lawyers for a single court case. Also, alternative business structures (ABS) were introduced by a Legal Services Act 2007, blow to this traditional system as it allowed non-lawyers to invest and become partner in law firm. These new ways of working could offer lawyers more flexibilities in the future, as well as providing a more attractive service for clients who benefit from a cheaper, more transparent service. On the other hand, disadvantages of fusion included a reduction in the standard of advocacy, loss of expertise which barristers are often used to provide expert advice, and the lack of the second opinion, where the advice of barrister may not necessarily be the same as the solicitor who instructed them. Indeed, the issues of fusion was considered by the Benson Commission back in 1979. The Commission considered the argument and came to the firm recommendation that the profession should not be fused. In conclusion, it is better to say no to fuse the profession, as this is supported by Benson Commission and an article. The Law Society mentioned that bar is much more efficient in terms of cost than solicitor. That is a direct function of the overall efficiency of the arrangement now subsisting between the bar and solicitors. Of course, the public is the beneficial. I stand with the split profession as its benefit is more than a fused profession.
June Tung and I will be discussing on ways lawyers are able to contribute to uphold the fundamental values of the English legal system. By starting off with our discussion, we will first briefly explain on what the English legal system is, where it consists of legislation, common law, and a host of other legal norms that have been established by the Parliament, the Crown, and the judiciary. In our discussion, we will be focusing on sources of law as the major fundamental values are strongly related to it. The sources of law are made up of 2 categories, which are the major sources and the minor sources. The major sources of law play a significant role in contributing to the system, as it consists of legislation, delegated legislation, common law, equity, and etc. Whereas the minor sources also contribute with its customs, international treaties, and authoritative taxes or law. In order to run the English legal system, there will be some fundamental values that act as a significant role in making sure that it can operate smoothly. Some examples of the fundamental values in the English legal system are public confidence in courts, European partnership, and international dependency. These fundamental values will be contributed by a wide variety of people or bodies that come from different industries and backgrounds. However, in this discussion, we will be focusing on how lawyers are able to contribute to uphold these fundamental values in the English legal system. A major fundamental value that lawyers can contribute to uphold the English legal system is common law inheritance. There is no better way for a lawyer to be at the heart of the legal system than to ask on how to handle its precedents. Lawyers that possess the skill to do good legal research are able to obtain previous precedents more efficiently and know what are the suitable cases to include. The most important doctrine will be stare decisis, which means to stand by things decided in Latin. Plays an important role in the judicial system, which is inherited from England. It is where the courts are bound to follow previous decisions, and it operates in theory to control and limit the ambit of judicial discretion. In the case of Cassell and Broom, Lord Reed in the House of Lords has stated that a decision that has been made previously in the higher court should be followed on the application of a law to a similar set of facts. Not to mention, the significance of doctrine of stare decisis is able to bring consistency, certainty, and efficiency in the English legal system. There are also a few types of precedents that should be taken note as well, which are the original precedent, binding precedent, and possessive precedent. These precedents can be divided into two categories, which are ratio decidendi and obiter dicta. Lawyers are expert in law and are able to identify the ratio decidendi of a case with ease, as they know which statement or principle is binding in nature, where obiter dicta will only carry a persuasive value to it. And this is how common law works. And lawyers as experts are able to utilize their abilities in this area to use previous decisions that will be binding on cases that have a similar set of facts. Hence, they are able to uphold the common law inheritance of English legal system. The second fundamental value that I will be mentioning is access to justice. There is a need for an accessible judicial system, as the significance of this accessibility is to be found in the opening doors of the courts to the public. Lawyers are able to help individuals, families, and businesses across the country in protecting their legal rights, resolving disputes, and securing financial support during their downfall. However, some people find it hard to have access to these services when they are in need of it. A legal representation in court proceedings are very important, as they are people that are trained to argue and convince the judge with the set of facts of a case. Hence, the clients will have a higher chance of achieving justice in courts, as they are equipped with lawyers that are reputable and experienced in the field. These lawyers are able to help their clients more speedily and accurately, as they have the knowledge and skills on accessing relevant sources and evidence. Legal aid is a government-funded scheme that helps to meet the cost of legal advice, and there are a few alternatives to it, which are law centers and citizen advice bureau. With the help of legal aid, people are able to get legal representatives in a more affordable way, and this helps the people in achieving justice. At this point, we are able to see that it is important to have a legal representative in court proceedings. Besides the legal aids that are mentioned just now, pro bono work is also made available, where lawyers will carry out legal work for free. There are a number of lawyers that voluntarily do pro bono work to help improve the lives of people in need. This can enable access to justice to individuals that are in need of advice, who are not eligible for legal aid and are without the means to pay for a lawyer. It has been mentioned that it is important to have lawyers to achieve justice. And to further explain on what Arisya has mentioned just now, the cap rank rule was invented as an obligation to ensure clients have legal representation when involved in a court case. The cap rank rule is set out in the Bar Standards Board Handbook and stated that if the barrister receives instructions from a client stating an issue which is relevant within their expertise field, they must accept those instructions if they are available on that period of time, irrespective of the identity of the client and the nature of the case. Cap rank rule can also help to prevent the situation of a bully scenario in court. Bully scenario is when a party without legal representation faces a big organization of an elite legal team. This kind of issue might lead to injustice and unfair court proceedings, as the opposition with a strong legal team is equipped with experience in litigation.
Another fundamental value that lawyers can contribute will be procedural fairness. When it comes to court proceedings, it is often considered to be a complex and complicated process if handled by an ordinary person without any legal knowledge. A legal expert can help in ensuring people that involved in court issue following the correct procedure, from filing a claim to outlining cases, examining witnesses, and to summing up the case. Besides that, this lawyer will also search for suitable case law and material to support and help their clients in raising arguments. A legal expert will also be able to point out when the opposition party has raised something which is unfair to his client and alert the judge on not adopting it. This point above shows the importance of having a lawyer in maintaining the procedural fairness of court. Also, lawyers will contribute in maintaining the fairness of delegated legislation procedure. Via judicial review grounds, we will be focusing on procedural ultra-vires. This means when a delegated legislation is passed without following the correct procedure can be held void. The lawyers has a role to come and uphold the fairness by representing his or her client in suing the authority or minister. An example of this will be the anniversary mushroom case, where the Minister of Labour failed to consult Mushroom Growers Association that it did not fulfill the requirements set out by Section 13 of the Legislative and Regulatory Reform Act 2006. Where in this act, it makes the minister to consult relevant people or organization when passing statutory instruments. Hence, the court held that this is invalid in terms of procedural ultra-vires against the mushroom growers. Moving on, lawyers can undergo training to be a judge. They are able to maintain court procedural fairness as they are able to decide on case and applying correct rules and regulations set out. In this area, the lawyers can reject any unfair adjournments requested by a party and use appropriate court order. So, we are able to see when assessing justice and finding fairness, these two fundamental values are related in court procedure. One of the reasons will be judicial review, as it is identified as the requisite feature of assessing justice and procedural fairness. This will open up the possibility of challenging the government policy on a systematic level. In judicial review grounds, it scrutinizes the lawfulness of a decision, action, or even failure to act in relation to an exercise of public function. Under these circumstances, lawyers will have an important role to uphold justice and maintaining the fairness of procedure in passing delegated legislation. In general, there are other ways for lawyers to uphold the fundamental values in English legal system, such as the dine-in tradition. If it is a way where Bar Council makes this tradition a mandatory thing for every junior lawyers to participate at least 12 qualifying sessions before entering to the industry. This tradition makes the junior lawyer can adapt the fundamental value more quickly, as there will be social occasions like formal dinners, music evenings, or boat party, or even educational events such as lectures, moot debate, and training weekends. With this session, junior lawyers will be able to learn and absorb the knowledge from senior lawyers through the interaction of this session. As the result of this event will ensure that senior lawyers will uphold the fundamental value by advising junior lawyers with the correct approach. Another way will be that lawyers are selected in a panel of jury are able to contribute in upholding fundamental values of English legal system. Lawyers can be selected as a juror under Criminal Justice Act 2003. Lawyers selected as jury will contribute a reasonable decision towards the case to ensure that justice is achieved. As the point we have mentioned above, it is clear to see that lawyers do have an active role in contribution of fundamental rights of English legal system. Lawyers, including solicitors and barristers, will not only contribute their knowledge by way of litigator, but also as a jury or as a judge. In conclusions, lawyers, as the biggest legal profession body, contribute their skills by applying relevant law to cases, and their effort in doing legal research are able to uphold the fundamental value.
Thank you, Jun. Now I'll be discussing the attributes that lawyers should have. First of all, good communication skills is one of the key to be a successful lawyer. Good communication skills means that lawyers are willing to listen to their clients patiently, take in relevant information, analyze it, and also able to articulate the solution to clients who are from different education backgrounds. Being a lawyer not just need to communicate with clients, they also need to communicate with judges, opposition counsel, and different stakeholders. So good communication skills is a fundamental attribute to carry out the role of lawyer professionally. Secondly, lawyers need to have extremely good research skills as well as strong writing ability. Being able to research quickly and effectively is essential to understand your clients and their needs in order to prepare legal strategies in advance. At the same time, it also requires analytical skills as lawyers need to absorb large quantity of information and sort it out in a short time. As we all know, in the actual world, lawyers don't stay in the court 24/7. Instead, they write a lot of legal documents. It is ultimately important for lawyers that are able to write effective, clear, and well-reasoned legal documents. Next, lawyers should possess integrity as their core value as a legal counsel. Integrity means you know what is right, what is wrong without supervising by others. Lawyers should always be professional, do not disclose the confidential information of their clients, at the same time do not corrupt for personal benefits. It is equally important to adhere to the ethics of a lawyer. For example, do not judge your clients, even your instinct tells you that they are guilty. Lawyers' job is not to define who is guilty, who is innocent. Instead, they do their best to defend for their clients' rights. Make sure that everyone deserves the same rights to defend fairly. In addition, being emotional balanced is also one of the most important qualities that lawyers should have. For example, you can't think someone is innocent because you feel pity towards them. In the legal world, evidence speaks, not empathy. Furthermore, lawyers should have the personality of perseverance. Do not give up at all times. Being a lawyer is never an easy thing to do. From law school to bar exam and to the actual legal world, it is a very, very difficult pathway to go. Being persevere can definitely increase the percentage of getting to the place where you want to be, regardless of your industry. Lastly, confidence is also one of the key qualities that lawyers should possess. Speak confidently and also look professional. It is very important as your clients need to feel that you are able to represent them if you are confident enough. In contrast, being confident but not overconfident. Do not think that being a lawyer, you are more prestige than others because it is a noble profession. Remember, be humble, be patient. It's equally important to become successful in the legal industry. In a nutshell, there are many qualities of attributes that lawyers should possess in order to carry out its duty professionally. Lawyers should always adhere to the ethics set by the local bar council and comply to it. Thank you and goodbye.